Good morning. May it please the court. Michael Efferman on behalf of the appellant Brian Tuck. I would like to reserve 5 minutes of my time for rebuttal.
Sure.
Focus my time this morning on the first claim raised in the briefs, and I will, of course, for any of the claims I'm not able to address during the oral argument, I will rely upon the argument set forth in my briefs. The first claim in the briefs concerns two different post-conviction claims that were raised by Mr. Tuck in his Rule 3.850 motion. Ground two, the defense counsel failed to present a defense theory, a reason for, or a motive for the alleged victim in this case to fabricate the allegations. And in ground seven, the defense counsel failed to properly object to the state's pretrial motion in limine. Let me begin by pointing out that in a case like this, I think it's extremely important that defense counsel, to the extent that defense counsel can, present a motive for the alleged victim to fabricate the allegations. I've handled dozens of these types of cases, and I think the first thing that a jury is going to ask, especially in a case involving a child victim, is why would this child be making this up? So to the extent that defense counsel can present that type of motive, that can make all the difference in the world, especially in a he said, she said case. So in this case, the motive that Mr. Tuck and his mother had presented to defense counsel prior to trial, and I'm going to refer to this throughout my argument in order to make it more comfortable as the bathtub activity, but I will explain it initially so I'm clear as to what the argument is. The allegation is that the alleged victim in this case would engage in sexual gratification when she was in the bathtub. And when she'd been caught several times by her mother, and when she would be caught, she would be punished, she would be spanked. And then on the date that the disclosure occurred in this case, the first time she ever made any claim that my client had engaged in improper activity, she was in fact taking a bath. Her mother had walked in, it was around Christmas time, and noticed that her genital area was red. And it was at that point that the disclosure came out. And it was ultimately, I think it was suggested by the mother, in fact, that no, I wasn't engaging in the normal bathtub activity. This is something that Mr. Tuck had touched me, and that's why there's redness. So the argument is defense counsel should have presented that motive about her reason to fabricate the allegation to avoid getting in trouble because she'd previously gotten in trouble, and defense counsel failed to present that. Now, with the evidentiary hearing, defense counsel gave a reason as to why he didn't present that. He said that he tried to, but the trial court prevented him from doing so. And as I've argued in my briefs, if you review how this played out during the beginning of the trial, defense counsel did not properly present this to the trial court. And this is pages 6 and 7 of the trial transcript. The record's clear that the state did in fact file a pretrial motion in limine. It listed 8 grounds, and one of them, ground 5, this is page 545 of the record, specifically referenced bathtub activity and water running down the alleged victim's leg. So the state wanted to keep that out. They were aware of it, obviously pre-trial. And if you look at 6 and 7, I'm just going to quote from it. I'll go through it quickly. Your Honor, there are several.
Mr. Offerman, it's not like your client counsel didn't have any defense. It wasn't his defense the fact that mom basically threw him out because he wasn't supporting them anymore?
I think when you look, and I've argued this in my briefs, counsel did not have any defense. And I've laid this out pretty clearly when you look at the argument in jury selection, and then you look at the argument in opening statements, and finally the closing argument. And I'll repeat those very quickly. Page 97 of the trial transcript, this is defense counsel. These are the elements that the state must establish. The first is that the crime was committed, that this poor little girl was sexually and lewdly abused. I suspect she wasn't, but my vote doesn't count. That's jury selection. The trial began shortly thereafter, pages later. They immediately went into the trial after they picked the jury. Now defense counsel in opening statements, page 143 says, because this is a very serious charge, and in all likelihood, VC was sexually abused. Very disturbing details. Just almost 40 pages earlier, he told the jury she wasn't abused. And now he's saying in opening statement that he suspects she was, and then turned to closing argument, page 544. This is the very beginning of his argument. Quote, a lot has just been made about the changing theories and approaches to the defenses in this case. The truth of the matter is, I don't have one, meaning I don't have a theory. And the state alleged that the theory was that he was being kicked out. That's certainly not something that was cohesively argued by defense counsel, either in opening or in closing. So again, I submit that there was no theory, and I'm going to address prejudice in just a little bit, but I do want to go back to what defense counsel, and this is important. This is the reason the post-conviction court denied this claim. The post-conviction court said, and this is page 316 of the record, that's the order denying the 3.850, quote, the court finds that Mr. Augustin's performance was not deficient. Due to the trial court granting the state's motion in limine, Mr. Augustin was precluded from presenting this evidence. If you review what was presented, I submit that this court cannot come to the conclusion that Mr. Augustin tried to present this. So let me read through real quick. The prosecutor, page 6. Your Honor, there are some motions in limine that the state filed. Defense counsel, there are several motions. I have no objection. The court interjects. This is the state's motion for order in limine dated 26 April. It has 8 paragraphs. The state's motion for an order in limine with 8 specific requests. Defense counsel, within the motion itself, it cites absolutely no legal authority whatsoever, cites to no rule, statute, or case. The court, okay. Mr. Augustin, I would argue it's legally insufficient and ought to be denied. The court, all right. Those 8 items you'll stay away from, okay? Sir, those eight items you'll stay away from, okay? Indeed. The case law in Florida is crystal clear. To preserve a claim for appeal, you must argue the claim with specificity to the trial court, put the trial court on notice as to why you want to present this evidence so the trial court can make a ruling as to that. That in no way appeared on pages 6 and 7. I relied upon the Fletcher case, which I submit is on all fours with the argument that I'm making. A very similar type of issue in Fletcher. Defense counsel failed to present something. In that case, the post-conviction court said the counsel was prevented from doing so because of the motion in limine the trial court's ruling. And this is what the 50CA said. Counsel herself inexplicably failed to oppose the motion in limine, stating at the hearing, Your Honor, I can't think of a legal basis on which to allow that in. This is the 50CA. Quote, of course.
Mr. Efferman. Okay, so the Strickland test, the test doesn't end with simply the counsel's deficiency, right?
Correct.
Okay, and you've argued at length, and I understand the argument on the deficiency. So how here was there a reasonable probability that the outcome of the proceedings would have been different given that?
Because this was an extremely close case, Your Honor, just like the Fletcher case where the 50CA found deficiency. This was a complete he said, she said case. There is no physical evidence, no DNA evidence, no eyewitness. In fact, the alleged victim was claiming this was occurring in her room, in her bunk bed, while her brother slept in the same bunk bed. He testified as a witness and specifically said he never suspected my client engaged in any inappropriate activity towards him or his sister. So there's an eyewitness who was actually there and said nothing ever occurred. Now, I understand the state may argue he was sleeping, this, that, and the other. But again, no physical evidence, no eyewitness. There was, and this is one of the issues in the summary denied, the claims that was summarily denied. There, in fact, was a sexual assault examination in this case, and the nurse concluded that there's no findings of sexual abuse. There's another argument in this case, and this is also some of the other claims that were raised by Mr. Pike in his Mr. Tuck in his 3.850. There was suggestiveness in this case. The mother is the one that initially suggested that my client sexually abused the alleged victim, and then there was an argument, and the defense tried to put on an expert to say that the way the CPT interviewer conducted the CPT exam, that there was suggestiveness and leading, which caused the alleged victim to make the allegations that she made. So in light of all of those concerns about the way this was brought out, and in light of the fact that there's no physical evidence, and my client is serving a life sentence for these allegations with no evidence other than her word to back it up. Again, I come back to what I started with. Imagine how strong this case would have been if defense counsel could have said, look, there is a motive. She made this up. She was caught again. She knew she got in trouble when she was in that bathtub, engaging in this bathtub activtivity. She was caught at this time.
There was also consistency. I mean, this is a 9-year-old, and there was consistency in her testimony, I think is what the trial court also focused on.
And that leads to another claim that's raised in the 3.850, that why in the world are we presenting this repetitious child hearsay testimony over and over again when all it does is to bolster the alleged victim's testimony. Getting into a separate issue, obviously this was an adult alleged victim. The jury wouldn't hear 5 different times from all these people that the alleged victim's side of the abuse. So yes, she said sometimes, she continued to allege that abuse occurred. I submit if you look at it closely, that's the consistency, simply that abuse occurred. There's differences in the way that she says it. The state, I was direct appeal counsel. The only only issue I could raise, and it was really a fundamental error type claim of a judgment of acquittal, that her evidence about how the penetration, how the conduct occurred in her pretrial statements was different than what she said at trial. At trial, she simply said it was being dabbed, and that's an issue because you need penetration if the object that's being used is a finger. Whereas pretrial, she supposedly said that there was penetration, but of course a pretrial statement, child hearsay, would never be sufficient in and of itself to support a conviction. So in fact, there's not consistency in the way she was making these allegations. And again, I want to come back to this. The state, if you look at the state's closing argument, they specifically argued, and this is page 543, exactly what I'm saying defense counsel should have presented. The state said on page 543, looked the jurors in the eyes and said, what motive is there for her to lie? Ladies and gentlemen, the jury believe her. Why would she be lying? Defense counsel had the ability to answer that question, to present the motive in this case, and defense counsel didn't do so. And defense counsel's the only reason found by the post-conviction court is because he tried and the judge wouldn't let him. Again, I said this in my closing argument below, and I'll say it again now. I often teach classes to lawyers about what you need to do to preserve the record. This is an example of what would not preserve the record. What defense counsel argued on pages 6 and 7 in no way put the trial court on notice, in no way would allow that issue to be presented on appeal. I couldn't present that issue on appeal. He in no way argued, just as the 5th DCA said, and I was getting ready to quote that, this is page 881 of the Fletcher opinion. Of course, the legal basis would have been that the testimony was relevant, going to the issues of bias and motive of the victim's mother and the victim herself, which were central to the appellant's defense at trial, a defense that would have cast doubt on the appellant's guilt if believed by the jury. That exact language from the 5th DCA and Fletcher applies in this case. If defense counsel would have argued to the judge, there is a reason. Judge, I know their jury's waiting. You're in a rush. You want to start this case. I know this motion in limine was filed pre-trial, and we're now just addressing it in the morning of trial. But Judge, there is something, 1 through 4 and then 6 through 8. Okay, we agree to those. But number 5, I do need to argue with you a little bit about that. That goes to our theory of defense. It establishes why there would be a motive to make up these allegations. So Judge, I would ask you to grant that, and let me explain why, for all the reasons I've just explained to you. If the judge would have denied it at that point, it would be preserved. And I've cited to the Markison case from the 1st DCA that says the failure to properly preserve a claim can amount to ineffectiveness. Had it been preserved, I think this court would have reversed on direct appeal, but then defense counsel clearly did not preserve it based on what I read to you earlier. The defense counsel said on pages 6 and 7, defense counsel was ineffective for failing to do so. Under Fletcher, this case should be reversed for that reason. I think at this point, unless there's any other questions about that, I'll reserve the rest of my time for rebuttal.
You got it, Mr. Upperman. You got about 6 minutes. The time?
Good morning, Your Honors and Counsel. May it please the court. My name is Allison Heim. I represent the state of Florida, the appellee in this case. Opposing counsel has touched on mainly just the first issue that was in the briefs. First of all, opposing counsel points out that defense counsel didn't challenge the motion in limine properly. However, even if it wasn't something that could have preserved the issue on appeal, the argument that the bathtub activity was central to the defense just wasn't there. That wasn't the defense. That's not the defense that trial counsel went with, so it could never have been an argument to put the court on notice. That's why the Fletcher case is different. In that case, counsel told the court, I can't think of a reason to oppose this, and so she didn't. But those witnesses in that case were central to the defense presented at trial. Here, this one incident was not central to the defense, and trial counsel did claim that he tried to oppose it. The court didn't even give the state the opportunity to make any argument on its own motion. The court said, well, it's granted, stay away from those topics. In a matter of seconds, it looks like, based on the trial transcript. And then counsel said that in this particular judge, in his courtroom, it would have been overtly counterproductive to continue to argue. So even though it may have been not a great argument for preservation purposes, it doesn't change what would have happened here, because it just wasn't an argument that was central to the defense. The defense at trial was that the mother pressured the victim to blame appellant for these allegations. That was the defense from beginning to end. That's what it was. The defense that appellant now asserts would have been better actually is a pretty unreasonable defense. Not only is claiming that a 6 to 8 year old child is self-gratifying in a sexual way in the bathtub is a little bit shocking. It can become less shocking if there's evidence to support that. However, there wasn't. There was one incident. This one incident appears to have happened about a year prior to her disclosure. There's no evidence in the record that this was a repeated activity, that it ever happened again. In fact, the state's motion in limine that precluded it called it the bathtub incident, just one. How can you base an entire motive to lie on one incident where she got in trouble one time a year or more prior to the disclosure? That particular defense also does not preclude or foreclose guilt, because both could be true. She could have been self-gratifying in the bathtub at the time her mother came in, but that doesn't mean that appellant wasn't abusing her as well. The mother asked her, "Is anyone touching you and making you feel uncomfortable?" That's when she said yes. It also makes it odd that she would call her mother to the bathroom and call attention to that area of her body if she's so scared of getting in trouble that she would go to the length to maintain a consistent story for years that he was touching her and give details and information like that just to prevent getting in trouble for self-gratification when she called her mother to the bathroom to look at the area. Also, just of note, she was showering at the time that her mother came in. She wasn't using the bath. During the evidentiary hearing, appellant said she would scooch up under the bath faucet that would fill the tub, and that's how she would do this. So at the time she called her mother and she was showering, we would have to speculate that before the shower, during the shower, I don't know, we'd have to come up with it on our own, that she used the bathtub faucet. It doesn't make sense. It leaves a lot more questions. There's a lot more holes that can be poked in it. Defense counsel deserves the deference that you get with 18 years of experience, which he had at the time of trial. And based on that and everything else in the state's brief, we would rely on. And if this court doesn't have any questions, then we ask that you affirm.
Thank you, Ms. Heim. Mr. Upperman.
Thank you. May it please the court. The state argues that this is not a defense. It was not defense counsel's defense. That's not what defense counsel below said during the evidentiary hearing. That's certainly not what the post-conviction court found in its order. The post-conviction court didn't deny this and say there was no such defense that could have been presented, or it wasn't even a strong defense. The post-conviction court gave one reason in this case, and that is the defense counsel attempted to present this defense and the trial court prevented it. If you look at the record in pages 382 through 384, and then again at 392, defense counsel clearly acknowledged this defense. On 384, what defense counsel was asked, but she was afraid of her mom punishing her for this bathroom activity. Sure, would you agree that it would be an excellent motive to fabricate a story, wouldn't it? Answer, yes, sir. So it's not that defense counsel didn't think this was a defense, didn't think it wasn't, in the way this question was asked, an excellent defense. Defense counsel's sole response to this during the evidentiary hearing was, I tried to present it and the trial court wouldn't let me. The state seems to call into question whether or not this activity even existed. The state was clearly aware of it. The state in its pretrial motion in limine listed it and tried to prevent the defense from going into it. So there's no question that this was an issue pretrial. The emails that were submitted that are defense exhibits from the evidentiary hearing that are in the record specifically show that this activity was brought to defense counsel's attention, and that's beginning on page 580 of the record. The deposition of the mother shows that this was being brought up during the deposition. So this is something that clearly exists. It was out there. It's not that it wasn't a potential valid defense. Defense counsel acknowledged it was an excellent defense. Defense counsel simply said, I couldn't go into it. And again, we know that's wrong. The state argued that there should be deference given to defense counsel. Defense counsel's reasoning was, I tried to present it and the judge wouldn't let me. There's no way you can read pages 6 and 7 of the trial transcript and say that defense counsel put this judge on notice at all, that what the state had listed in its motion in limine would be relevant in this case or would be a theory of defense. That is clearly deficiency. Just as in the Fletcher case, defense counsel had to put the trial court on notice that this is relevant to our theory of defense. And then the state, and I'll conclude with this, the state seems to be arguing that, look, whether this would have been believed, who knows, we don't know. That's an issue for the jury to decide. But without question, as I started with, having no motive put my client in a very difficult position. This was a close case, but yet the state got to get up in closing argument and look at the jurors and say, why would this child lie? Defense counsel could have responded and said, here's why she would have lied. She engaged in this bathroom type activity. She was doing it again at the time that she made these allegations. She did it to deflect so she wouldn't get in trouble at Christmas time, and instead pointed the finger, or was suggested to her so she could point the finger at my clients. That is a very strong motive. So the question that the state asked in closing could be answered. And in light of how close this case was, in light of the fact that there was no eyewitnesses, no evidence to back this up, my client shouldn't be spending life in prison without the opportunity for the jury to hear all the evidence. Here, what defense counsel himself acknowledged was an excellent motive to fabricate and then make a decision based on all that evidence. So for those reasons, I'd ask this court to reverse just as the 5th DCA did in Fletcher. Thank you.
Thank you, Mr. Upperman. And when you leave, you want to click the button on the lower right-hand side of the Zoom screen, and it says